Good afternoon, everyone. I want to thank Alan, I want to thank Joel for the invitation to be here today. Also thanking AAAS for putting on this conference on scientific evidence in the courts. So this next panel is going to be on in the minds of the jury. And just to introduce myself in my moderator role, I am Caroline Montojo, President and CEO of the Dana Foundation, which is a private philanthropic organization based in New York City. And just last year, we refined our mission focus to the intersection of neuroscience and society. And so our mission is to advance neuroscience that benefits society and reflects the aspirations of all people. And so with our funding, we support work at the cross-section between neuroscience and other fields such as ethics, law, humanities, and social sciences. So it's really a pleasure to be here today. I should also mention that the Dana Foundation has supported AAAS in their judicial seminars on emerging issues in neuroscience since 2007. So very nice to see that work progressing. All right, so a little bit about our panel here. Well, I am a neuroscientist by training, and we do know in neuroscience that neurotechnology is not yet capable of looking into the minds of jurors and interpreting the minds of jurors. So the panelists and I in our preparatory discussions actually thought that perhaps a better framing for this panel is improving understanding and evaluation of scientific evidence by jurors and judges as well. And so this session is going to examine what we know about human memory, psychology, comprehension, and decision-making, and also the factors that influence understanding of complex scientific information, including the adversarial system, as well as judicial gatekeeping. We're also going to talk a bit about strategies to improve the current system to really optimize education and learning about science information. So to start us off, we're going to have talks from each speaker, about 10 minutes from each panelist, followed by about 25 minutes of discussion. And so I would like to ask the audience to start to think about what kinds of questions come to your mind, both in this room as well as those on Zoom. And then we'll have a Q&A period at the conclusion of all of the speaker remarks. So first, I'd like to introduce our first speaker. This is Emily Murphy. She is Associate Professor of Law at the University of California College of the Law, San Francisco. Professor Murphy's research focuses on the intersection of neuroscience, behavioral science, and the law. She writes about the use of neuroscience as evidence and how neuroscience and behavioral science shape policy and legal systems. Her work has been published in many venues, including the Stanford Law Review, the Journal of Law and Biosciences, and many others. Professor Murphy earned her A.B. magna cum laude in psychology from Harvard, her PhD in behavioral neuroscience and psychopharmacology from University Cambridge as a Gates Cambridge Scholar, and her JD from Stanford Law School. Please help me in welcoming Professor Murphy.
I'm honored to be here, coming from San Francisco. We were formerly called the University of California Hastings College of the Law. We are now University of California College of the Law, San Francisco. And I'm going to do just basically some table setting here because I think my colleagues here have done a lot more empirical work directly on juror decision making. But I'm going to tell you a little bit about how memory works, how it doesn't work, and both in the context of the memories of jurors who hear evidence, and not just scientific evidence, but all kinds of evidence, but also memories of witnesses, which is, of course, an important component of courtroom evidence, whether or not it's scientific percipient witness testimony about their experiences as well. How that memory is understood and evaluated. We've seen, obviously, major scientific advances in the understanding of the specific context of eyewitness identification memory, which has led to substantial procedural changes in the legal system. I'm here to tell you, I think that brain and behavioral science, and especially the neuroscience, should maybe push us to think a little bit harder about all kinds of memory and witness memory and that they testify to. That said, I don't necessarily have any perfect solutions, but this data is, of course, is not mine. but sets the table with what does the public generally think about memory? And this is relevant because it's, of course, the public who becomes jurors. And versus expert opinions on memory. This is a nationally representative sample, and when given a prompt such as human memory works like a video camera, accurately recording events we see and hear so we can review and inspect them, in green, more than 50% of the general public agrees with this statement. Almost no experts, all experts either strongly disagree or mostly disagree with this statement. Similarly, once you have experienced an event and formed a memory of it, that memory does not change. More than 50% of the public generally thinks this is true. There's an idea that memory works like a video recorder or a filing cabinet, and you simply flick through and find out what happened. No experts think or know that this is true. And this is true for all autobiographical memory, and I would posit that if the public paused to think about this for a second, how many of you have ever experienced déjà vu? Where you feel like you're experiencing something that has happened before. That's a memory error. It's an autobiographical memory error. These are common, these are normal. We have no idea what the base rates of autobiographical memories are. And yet, most normal percipient witness testimony is the recounting of autobiographical memory. And indeed, testimonial capacities are premised on assessing the quality of a witness's memory, and the jurors are empowered to do this. But memory is not stable. And psychologists, of course, have known this for years, and neuroscientists have been uncovering the molecular level mechanisms that make it plastic. An event is encoded, it is eventually consolidated in neural circuits, and there is some degree of fixation. Our memories are reasonably stable, but every single time a memory is reactivated, it becomes labile or plastic, subject to modification. This can be done by injecting rats or delivering to people various types of protein synthesis inhibitors, even specific behavioral interventions, and to disrupt a memory, or simply having a novel experience, which leads to an updated memory. Sounds perhaps concerning. This is the normal process of learning. This is how we learn and update our knowledge bases all the time. But memory is far from stable, and it's far from fixed. This is just not something the general public who come and sit on our juries understand. I could give you an hour and a half to 3 hours of the data showing this, but to summarize succinctly, what we know about memory. And again, psychologists have known these things for years. Neuroscience is confirming this both at the molecular level and also, as I'll talk about next, sophisticated brain imaging techniques are confirming that there is no video recorder. There perhaps may only be a subjective truth in our brains. That's what there is. Memory is constantly being reconstructed each and every time it is accessed. And of course, I said it's malleable, subject to changes. And this is not a flaw. This is normal. This is how our brains can be adequately efficient to take in and process the information that we are confronted with in our daily lives. Significantly for the legal system, though, it's important to know that recalling a memory via questioning, or say witness preparation, or say a deposition, or even just rumination, makes it vulnerable to change. And false memories are extremely easy to create, nefarious or otherwise. They're extremely easy to create. Even just imagining an event can lead to false memories. Importantly, we talked a lot this morning about Daubert, and I know we'll be doing that again. We have no sense of base rates of false autobiographical memories. We do know that there is significant variation even in non-traumatized normal people talking about normal daily life events. We have some sense of, there is some investigation into how base rates are affected by the experience of a particularly salient or traumatic memory, but not all witnesses coming into a courtroom are necessarily talking about a particularly salient or traumatic memory. A lot of civil litigation is incredibly boring and involves business people doing routine things about which they would have no particularly salient memory, except perhaps when they then are prepared by their attorneys. And then, as I mentioned, this is the particularly interesting thing, I think, in the work I've been doing, that memories can be detected. by sophisticated brain imaging techniques. And I'm not talking about lie detection. I'm talking about autobiographical experience memory detection. But the upshot of all this work is that brain imaging technology is just confirming that there is no objective truth video recorder in our brains, only the experience of subjective truth. And that essentially, there's a number of different ways of putting this very long law review article synthesizes, at least to date, and there's been even more accumulating evidence since then, the use of extremely interesting real life, like people wearing video recorders around their neck for 3 weeks at a time, and then being asked to assess their subjective or experience of memory, where the researchers have the objective truth, unlike any kind of forensic scenario, right? But that using brain imaging data with multivariate pattern analysis and machine learning techniques to process massive amounts of data, training pattern classifiers rather than testing a priori kind of which area of the brain lights up hypotheses, these machine classifiers are pretty good. They're quite good at determining whether someone has a subjective experience that their memory is real, but not whether the memory is actually real. I think that what we're seeing here is that brain imaging techniques are confirming that we can probably never distinguish between a true, veridical, like empirically true memory and a false but honestly believed memory, and that this is fundamentally a biological problem and not really a technological problem. So what does that mean for witness memories? Every time I've educated judges about this, they're like, well, okay, so? There are substantive solutions to Professor Allen's points earlier, increasing reliance on documentary evidence and the decrease in testimony, and other evidence scholars are writing about this. That's probably better because documents aren't as molecularly plastic as our brains. And in the case of eyewitness testimony, court procedures have been modified in some states to account for the bulk of the overwhelming weight of the scientific evidence, saying that, and then explicitly instructing jurors that memory does not work like a video recorder, that it is much more nuanced than that. Could we introduce a similar jury instruction, something like that, to show how, say, well, jurors, you may be a human who has experiences and think memory works pretty good, but actually you can't trust anything, and therefore you should take all of these witnesses skeptically. Judges I've talked to are like, well, that's just pragmatically unfeasible. It's going to undermine all kinds of things. They might just ignore it because it makes no sense to them. What would they do with this? I don't think there are easy answers, such as a particular procedure to develop with a particular type of witness memory testimony. But I think we have to consider these things, and which are going to bring in, and I hope we can have a discussion about this, the system legitimacy concerns, both in terms of the types of evidence that are considered to be, that how they are given weight and how jurors are instructed to weight them. I take this point from my colleague and mentor, David Fagman, who's a longtime colleague of other panelists here, that this law-science interface is one to be managed and not perhaps solved. And this is in part because of in whole, because of the structural and contextual factors between scientific production of knowledge and the adversarial system. They have entirely different incentives. There are structural incentive-based flaws or problems in both, and they're at odds. The graphic here is meant to refer to one of the things that David and his colleagues have developed, to the group to individual inference problem. There's also, of course, the, excuse me, well, we'll stick with just the group to individual inference problem, but I am wondering if we can educate jurors through things like explaining to jurors, and to judges perhaps, frameworks for understanding exactly what they're being asked to do. I would consider these metacognitive frameworks, but the idea of, for example, group-based evidence being what David would call framework evidence, and the individual evidence at issue here being what they would call diagnostic evidence. Framework versus diagnostic evidence is something that makes intuitive sense to scientists and to clinicians and legal practitioners, and it's not part of evidence law or doctrine. Perhaps it should be. It's not a substantive solution, it is still perhaps a procedural solution, but because this is a problem of management, maybe that's the best we could do. I look forward to further discussion. I would welcome anybody to reach out and talk about this work or others. And thank you very much. I look forward to my panelists.
Thank you very much, Dr. Murphy, and thank you for setting the stage for us with the state of the neuroscience, psychology, and behavioral science. A very sobering assessment, but I also appreciate the discussion we'll have later about potential solutions forward. Next, I'd like to welcome Michael Sachs to the stage. Dr. Sachs is a Regents professor in the Sandra Day O'Connor College of Law and Department of Psychology at Arizona State University. He's also a faculty fellow with the Center for Law, Science, and Innovation at ASU. Professor Sachs's research interests focus on empirical studies of law and the legal system, especially decision-making in the legal process, evidence law and the law's use of science, the behavior of the litigation system, and legal policy affecting medical patient safety. He's served as editor of the Journals of Law and Human Behavior and Jurometrics, and as president of the American Psychology Law Society. And his article on the behavior of the tort litigation system has been the most cited tort law article in the past 25 years. So I'd like to welcome Dr. Sachs to the stage.
All right, let's see if I can figure out how to get my slides up here. Joel? And is this the, keyboard hiding down below? Thank you. And which button? Left, right, okay. Thank you, and I could say good morning to you because where I come from it is still morning. No one is likely to be surprised if I say that when a person has little or no familiarity with a technical subject, solving problems in that domain can be a challenge. But I want to give you a couple of concrete illustrations of that. These graphs are just to convey the idea that there are numerous different ways of presenting data to people. A researcher tried to figure out if some ways of presenting epidemiological data would facilitate jurors' understanding of whether the data supported or did not support an inference of causation. The jurors were at a large urban courthouse, passing time until needed for trials. Different prospective jurors were shown different graphs, different data presentations. None of the presentations was able to improve their accuracy in making sense of whether causation was supported or not above approximately 50%. Essentially guessing nothing was improving on that. For 10 years, I taught state appellate judges at the University of Virginia's summer LLM program. Early in the course, I would present them with some interesting little puzzles. Most of you would regard them as little puzzles. Here's one example. Diseased tissue is removed from the colon. You have to then reattach the ends of the colon. And the question I posed to them was, imagine you are a group of gastrointestinal surgeons, and there's a debate in your field about whether method A or method B is the better way to rejoin the colon. How would you approach the problem of resolving that debate? The typical response, and I would stand there quietly while they waiting for someone to offer something, they were quite stumped at how one would approach that. Now, these examples don't mean that people cannot learn new things, but the teaching and the learning are going to take time and effort and perhaps some ingenuity, especially when time is limited, as in a trial setting. Several lines of research suggest that when people, and these lines of research are all dual processing models of cognition, and you will hear more about it from the next speaker. But they suggest that when people lack knowledge needed to think carefully about a problem, they rely instead on superficial indications, second order, third order, indications of what the correct answer might be. The expert evidence gatekeeping process might exacerbate that phenomenon in the jury context. There is some research. There is both an intended and an unintended effect of gatekeeping. The intended effect is to prevent false, unvalidated, misleading evidence from being presented to jurors. The unintended effect is that when evidence is allowed in by a gatekeeper, and the jury is aware that in a trial setting the judge is passing on some of the evidence, the jurors will give more weight to the evidence than it deserves. Some research which has presented evidence to mock jurors in a trial simulation setting and asks them to evaluate that evidence compared to doing the same task, same evidence, outside of a judicial setting. Outside of the judicial setting, people are more skeptical of, more questioning of the evidence. Thus, there is reason to believe that when judges engage in loose gatekeeping, they risk serving up shaky evidence to which jurors will then give inordinate credit. I want to give you some examples of loose gatekeeping. One example is that a study by the FBI found that over 90% of reports and testimony, microscopic hair comparison experts were giving exaggerated opinions, conclusions about what their observations about microscopic hair. Hair found at the crime scene, hair from a suspect compared. They were making statements that the field recognizes are not possible for that technique, making pinpoint, this is the person, to the exclusion of all others' opinions, when that is simply not possible. You've heard earlier there have been a number of dead or dying forensic sciences, voice prints, comparative bullet lead analysis. Not all of arson investigation, but nearly 24 arson indicators. Those are essentially dead. Bite marks, I thought it was dying, but from what I've heard today, it may already be dead. It's a question of how many nails are in the coffin. These are techniques, expert evidence, that were admitted. I'm going to grab a little water. These experts and their techniques were cheerfully admitted into evidence for some time, and then they stopped showing up. And they didn't stop showing up because judges figured out that they lacked validity. They stopped showing up because some other institution figured out that there was a problem, or in the case of arson indicators, the field itself began to do studies on the validity of its beliefs. It's kind of like testify first for 10, 20, 50 years and validate later. Another indication, you've heard this earlier, the National Research Council report on the needs of the forensic science community. Much forensic evidence is introduced in criminal trials without any meaningful scientific validation, determination of error rates, or reliability testing, and the courts have been utterly ineffective in addressing this problem. And my last indication of loose gatekeeping, the gentleman in this photo is Barry Fisher, who at the time of the NAS report was the director of the Los Angeles County Crime Lab, and he was president of the American Academy of Forensic Sciences. And in addressing an audience of judges about the NRC report, he said, "You have given us a free ride." And he went on to say that if you judges don't change the way you do things, we labs are not going to change the way we do things. So in those examples, the intended effects of gatekeeping failed and the unintended effects probably occurred. People have been thinking about this problem for at least since Learned Hand's article in 1901, and I won't go into the details of these, but people have been thinking about semi-radical solutions. Some kind of fundamental reform such as these might be the best hope of getting the best scientific evidence to juries. But since none of those is the present system, and jurors will have to deal with whatever expert evidence their gatekeeper has seen fit to let through the gate, the law should help juries do the best job that they can, and on that, we turn to Valerie Hans. But first, a proper introduction.
Thank you very much, Dr. Sachs. And finally, for our last speaker, we have Dr. Valerie Hans. And Dr. Hans is the Charles F. Rechlin Professor of Law at the Cornell Law School. She conducts empirical studies of law and the courts and is one of the nation's leading authorities on the jury system. Trained as a social scientist, she's carried out extensive research and lectured around the globe on juries and jury reforms, as well as the uses of social science in law. She's the author and editor of 10 books and over 150 research articles. Professor Hans is also studying the diverse forms of citizen participation in legal decision-making in other countries, and her research and that of others are summarized in a co-edited book, Juries, Lay Judges, and Mixed Courts, A Global Perspective. Dr. Hans, please welcome you.
Thanks so much, Joel, for setting things up. In an article, Improving Judge and Jury Evaluation of Scientific Evidence, Michael Sachs, who you just heard of, and I laid out several strategies that courts can use and lawyers can use to try to enhance the ability of judges and jurors to understand and to apply scientific evidence. And you see the approaches that we identified listed here are panels on juries, so my comments will focus on those, but I'm sure Michael and I would be thrilled to talk about any of them with you, including one of the more radical ideas about changing generalist judges and representative juries to special juries and expert judges in the legal system. We've got a paper on that that was published in Daedalus, a special issue of Daedalus, and we'd be delighted to send you a copy. So just get in contact with us. So to understand the way that juries process scientific evidence, it's very helpful, I think, to know more generally how jurors respond to trial evidence. And Emily got us started on this task. But we now know through research on jury decision-making that rather than mechanistically adding up evidence, favoring one side, and comparing it to the evidence that is accumulated on the other side, as jurors take in evidence during a trial, they attempt to form it into a narrative, a story that hangs together with causal explanations and can be influenced by a variety of psychological factors, including motivated reasoning, what do you hope to have as the result of it, and also shortcuts like heuristics. Now, evidence that is consistent with the story that is developing tends to be incorporated readily into that story. And evidence that is inconsistent or that might be challenging or difficult to kind of figure out how to incorporate might be disregarded or undervalued. We do know from research with jurors that they tell us scientific evidence, statistical evidence, economic evidence, and probability evidence. All of those are particularly challenging and particularly difficult. And so the hazard is that, if jurors are struggling to integrate that into a developing story, those kinds of pieces of information that might be very central and valuable for the case will actually be underutilized. Michael mentioned the two different types of thinking, and he laid it out very nicely, the kind of system one approach, which is instinctive and quick and automatic, doesn't take much effort, and system two thinking, more deliberative, slower, rational, often used in complex decisions, and takes a lot of effort. Interestingly, jury trials are really set up to encourage system two thinking, right? I mean, they have extensive adversary presentations of evidence. There are opinions and arguments by the lawyers, by the judge. And furthermore, there is the opportunity for deliberation where people are able to test their constructions and interpretations of the evidence. So there's a lot going for jury trials encouraging system two evidence. But the subject of this conference, scientific evidence, when it's difficult, the hazard is that people might fall into system one thinking and rely instead of really processing the evidence thoroughly and thoughtfully, rather rely on more superficial cues, perhaps like simply the credibility of the individuals who are giving the testimony. So I think the question for us, as we think about how to improve jury trials and enhance understanding, is how to encourage more deliberative and thoughtful approaches. Just a couple of thoughts of the types of things that we could be thinking about. I mean, starting with jury selection. One of the things that we have to confront is that confidence in science as an enterprise has dropped over the last 20 years or 25 years. This particular recent Gallup poll shows an even more concerning development, which is the drop has been differential and it's been partisan. And people who tend to be registered Republicans actually have dropped in their confidence in science more than independents and than Democrats. So something that is worrisome. There's been a drop overall, but then in addition, there's been a more concerted drop. And I think one of the things that suggests is in jury selection, not that you should be checking out necessarily, what party your prospective jurors are enrolled in, but to anticipate that questions about the credibility of scientific evidence are going to be on everybody's mind, and that you should anticipate concerns, and as evidence is presented, really think of ways to meet concerns and address in advance, knowing that there will be worries about, for example, contamination of evidence. The other thing in jury selection that we know from research is that a diverse jury tends to be a jury that engages in more thorough and thoughtful and vigorous discussion and deliberation. So if you are aiming for higher quality fact-finding, you have a case with very complex evidence, you want to maximize that. The idea of bringing in people from a broad range of the community has lots to recommend it, in part because during deliberation, they may well test each other's interpretations of the evidence. And we also know that larger juries are better at ensuring diversity. They offer an opportunity to get a more representative sample, so even the difference between 12-person juries and 6-person juries can create significant improvements in you being able to bring into the courtroom all of the components or elements of the community. The other thing, once we get past jury selection, is making the trial itself a more educational experience. And here I've listed a number of ways that Michael and I talked about in our article and also are represented in a fair amount of research. One of the things I want to say is that everyone listed here, there is at least some research indicating that these can potentially be effective ways of maximizing understanding, enhancing understanding. So there are obviously lots of ways that a scientist could maximize the comprehension of her testimony, but in terms of how it is presented, but the courts can do a lot too. For example, it's often common for an expert to be scheduled at the expert's own personal schedule, maybe out of order in the trial and not necessarily adjacent to another expert, especially another expert for the other side, because usually one side goes first and the other side goes second. Courts might consider the idea of putting expert testimony on an issue back to back so that it's a better opportunity for people to compare and contrast. It's not quite like the hot tubbing of Australia, but it gives people a fighting chance to look at and compare, while things are still fresh in their minds, ways in which the evidence might differ and points of difference, points of similarity. The other thing we know, again, from a fair amount of research, is so-called active jury trial procedures and trial practices can help jurors understand the evidence, remember the evidence. It seems completely banal, but allowing note-taking was not really permitted in all of the states in the United States until the last decade or so. And people worried about, if they're taking notes, they're not paying attention to people's faces as they're giving testimony. So that's one thing you can do. The complex cases in particular can benefit from note-taking, not only note-taking, but also having checklists, decision trees, detailed verdict forms to help guide people in these sets of decisions they are making. One other thing is allowing jurors to submit questions, which has gotten a lot of resistance from attorneys, but is especially when it is possible to ask people, especially when it's possible to ask experts questions, can be really quite helpful. Deliberation, it turns out, is another place where scientific evidence can be discussed and debated, and actually understanding is refined. One of the things that scholars have learned is that formal education, and especially math and science courses, is associated with better understanding of evidence, but deliberation itself can help. To show you here a slide from a project that I did of a mock jury study involving the phenomenon of mitochondrial DNA evidence. And we gave people a multiple choice test about the scientific evidence that was presented in the case to see how well they would do. And one of the things you can see in this slide is people with more formal years of education did better, both before and after. But what you see here also is that people with lower levels of education, especially the modest number of people who only had a high school education or maybe less than high school, got the biggest benefit from the deliberation with others. So I'll just here conclude with a few comments. I mean, we do know from jury research that despite all of the things that we've been talking about on this panel, generally juries do a pretty good job, even in complex cases. The benefits undoubtedly come in part because many juries are diverse. They engage in robust deliberation, the collective sharing of understanding of scientific evidence, and some help from lawyers and judges. It's also the case that, and this is a point that Rick Lempert, who's in our audience, had made in one of his excellent articles on juries in complex cases. Juries don't have to understand the evidence like an expert would. They only need to understand it so that they can use it in the case. And in most instances, that does happen. However, we, lawyers, judges, and the rest of us can help juries understand all of the time, as opposed to only most of the time. Thank you.
I can use this one too. Yeah.
This one just.
Okay. Well, if needed, we can share the mics among the. Okay, yours is working now. Great. All right. Excellent. Thank you so much for your remarks. I thought that was such a wonderful overview, bridging from the neuroscience and psychology to thinking about judicial gatekeeping and loose gatekeeping and unintended harms, all the way through to thinking about ways to make the trial experience more educational in terms of comprehending and evaluating scientific evidence. So what we're going to do now is we have some time to move into an open Q&A. Oh, thanks, Joel. We'll have some time for an open Q&A. I see we already have a question here from an audience member, and I know that Joel will be monitoring the Zoom chat for us as well. So I'll go ahead and invite our audience member here.
Thank you. These were really interesting presentations. And I had a question, Professor Hans, earlier on you said maybe we can think about specialty juries or expert juries or expert courts, and I'm curious about you talking more about that. But also, I'm wondering, like in conversations I've had with people about this, it's come up that because of the Sixth Amendment, this right to be tried by a jury of your peers, that my understanding is that we're kind of limited in the way we do jury selection here, in that we can't have expert juries, we can't have these special panels, but maybe if the scientific or the admissibility piece was partitioned out, maybe that could be an expert jury type thing. Anyway, curious.
Yeah, thanks for that question. So Michael and I talked about the possibility of expert juries. The law does not, in the United States, there's, so far as I know, there's no definitive judgment by the U.S. Supreme Court that expert juries or special juries would be, violate the Constitution. But I would say the two of us don't think it's a great idea. I mean, one of the things that you would get is perhaps an advantage of being able to understand scientific evidence. If, for example, you picked your special juries for those who had, I don't know, engineering training in a case that involved engineering issues, or science and math training for evidence, the crucial evidence in a case that was extremely difficult on that score. But you would give up a lot too. And one of the things we have learned through research is the value of a jury that does represent a cross-section of the community. And the robustness that I spoke of for a diverse jury would be presumably not as, it would not be as robust if you had people who were selected along one line, and one characteristic like education. And people also might, there might be inadvertent ways in which you would result in a jury that absolutely did not represent the community. So might suffer in terms of legitimacy. For all those reasons, I think we think that should be a last straw. Did you want to say anything about expert juries? Okay, all right. That's all then.
Thank you very much. I'm Brad Weibel, an editor at Science Magazine upstairs. I should say it'll be obvious in about 10 seconds when I ask my question, but I'm not a lawyer. The suggestions for how to improve this, tools and supports for juries made a lot of sense to me, so much so that, I ask, why wouldn't you do that? Because if I'm a scientist, those are exactly the approaches and tools that we tend to use to engage with the information and to arrive at understanding. Use graphs, take notes, have discussions, ask questions, et cetera, et cetera. And so, again, I'm sure there's a million and one good reasons why juries are set up to not be able to do that, but it almost seems like we're asking people to engage with information that's completely removed from the context in which the information is developed and understood. It's almost as if I'm saying to you, it's important that you be exposed to someone who speaks a foreign language, but I absolutely don't want you to really know anything about how people learn to speak that language. And again, I don't know what my question is, but it seems like no wonder none of this works if that's the handcuffs that we put on the system. I don't know if that makes any sense, but.
We agreed that I'll field that one. This should be working. No? Is it? No? Okay. There is a really fun little videotape. I forget who made it. I think the Pima County, Arizona. Oh. Anyway, they show a classroom, a teacher in front of a classroom. And the teacher essentially says to the students, think of your average college class. The teacher says to the students, you're going to hear from a lot of experts who know a lot of things that you don't know anything about. You're going to have a problem to solve, so they're going to talk to you, and you cannot talk. You can't ask them questions. You can't discuss it among yourselves. You can't take notes. He goes through all the things we do with juries. And the students are looking rather perplexed because that's not how you normally learn things. All I can say by way of explanation is that my best guess is that lawyers more than anybody, but also judges, want to keep things very well under control and disciplined. Trial lawyers are control freaks, and if it gets out, anything they can't control makes them very nervous, and they probably have helped shape the rules to do that. But that has changed over time, as Valerie alluded.
And if I could add that, I think part of the reason is that They always did it that way. And also we had less complex cases. And some of these questions and issues and struggles jurors are having, I think, are a result of increasing complexity in the cases they deal with. But I totally agree with Michael's point about the role of lawyers. Think about juror questions. I mean, it makes so much sense. You have an expert come and talk about really complicated information, and, you know, as an expert, you know, as somebody who has testified myself, I would love to know, like, what are the questions people have? I'm here on the stand. I want to make sure they understand what I think is the right way to look at this. Yet, what a violation this is of the lawyer's traditional role of controlling the questioning. Now, there are now a number of courts in the country that allow jurors to ask questions, and they usually do it under super controlled circumstances. So the violation to lawyers, I don't know, dignity and ego, and but also the rules of evidence don't get out of hand. So a juror might have a question. It is reviewed by the judge, also given to the attorneys to make objections to, and typically only if the lawyers don't have serious objections and the judge approves it as a question that can be asked, will the person be allowed to do it. And I think will be allowed to answer. And I think that helps to manage some of the traditional role of the lawyer as the one who's in charge of the questioning.
I have one last comment. I was talking to a federal trial judge from Texas who was telling me he had a month-long, very complicated, lots of experts case. A bench trial, no jury. And after an expert witness was examined and then cross-examined, and the lawyers thought, okay, that's that, the judge said, pardon me, I want to have a conversation with the expert. Go up to the whiteboard, and we're going to conduct a colloquy like I'm a student in one of your seminars. He said both lawyers rose to object. Of course, he's the judge, so he could overrule them. But it's just another illustration. The lawyers don't want people messing up their cases.
I want to pick up, though, on a theme that has emerged, which is the responsibility of the legal profession, not just those who end up as trial lawyers, which is truly a very tiny fragment, but almost all judges, nearly all judges, were started out as lawyers. And fundamentally, I think one of the lawyer's core functions is to be a translator of complex information into essential distilled narratives, either to your client or sometimes to a jury. Guess how many prerequisites there are for law school? I mean, in terms of like undergraduate courses you need to take. None. A simple intervention that I would strongly favor is that prerequisites for law school should include at least one basic course in psychology, because what are we doing? And the other would be a basic course in statistical inference. And lawyers should have a passing familiarity because their fundamental job is as translators to take these things. So law schools in the ABA could do that starting next year, roll it in over a few years. That would be the world I want to live in.
Thank you, Emily. We have one more question if we have time. Is that all right, Joel? No, okay, please.
Well, as one of those tiny fragment control freaks, I've been a trial lawyer for 40 years. One very quick vignette. I sued Microsoft once, and I got to be very good friends with their in-house chief IP counsel. And Andy and I were talking one night over drinks, and he said, why does every case have to be a morality play? So getting back to your system one, system two. My response to him was, because it is. Okay? This system isn't supposed to be getting objective truth. It's supposed to be settling disputes between human beings. So there is an emotional aspect to it. And we're never going to get away from that. No AI is going to replace that because people won't accept it if they don't feel that they've been heard. But my question is for you, I'm interested in actionable intelligence. You've raised some very good points, none of which are surprising to me after 40 years in a courtroom. But what resources are there? It's actually improving. We're doing some of these things in some of the more progressive courts. You're allowed to take notes. You're allowed to ask questions under very controlled circumstances. We're getting there slowly. But what actionable intelligence can you provide? Because what I need is when I go to a judge and say, I want them to take notes, I want them to ask questions, he's going to say to me, well, what's your proof there's a problem? And I need scientific consensus that I can present to them and say, look, here's a stack of 12 papers that show that this is a problem, and there really isn't any dispute in the scientific community among psychologists that it is a problem. So let's do it right. Have you, and further to that, have you gone to to do this state by state is going to take you forever, lifetimes, okay? Have you gone to the Federal Judicial Conference? Have you gone to the Federal Judicial Center, the Judicial Conference of the United States? At least you could get 96 courts together at that point.
When you ask about actionable intelligence, are you asking about studies?
Studies, papers, something concrete I can present to a district court and say, do it this way, and here's why.
They exist. Get the article, get our article, look in the reference section, and Valerie ought to tell you about her study on mitochondrial DNA, which was done by the National Center for State Courts, and a state trial judge who was, I guess he had retired and gone to the National Center, put this whole thing together, got Valerie to help. And so they studied, I don't know why I'm telling you about Valerie's study. They put together an experiment where jurors were going to learn about mitochondrial DNA, but some of them would just have to sit passively and hear it. Some would be allowed to take notes, some would be allowed to ask questions, some could do other things, some could do all of those things, mixture of those things, and then they measured how much better the jurors could deal with whatever the problem was that they were supposed to be deciding. These studies do exist. I don't know that, I had a law professor, well, I'll just tell you his name, Guido Calabresi, who once said about his scholarship, he said, as a scholar, I'm a bus, not a taxi. So I don't, meaning it's not his job to go out and fix things. It's his job to think about solutions, publish them, and then they are there for whoever in the world wants to use them, attack them. So although I am sure we'd be very happy to talk to any group that wanted to hear about these things.
Thank you.
And bring along a list of citations.
All right, excellent. Well, thank you so much for all of the questions, and I'd just like to thank Dr. Murphy, Sachs, and Hans for their participation today. It sounds like there are quite a few actionable items that can come from this panel alone, so looking forward to further discussion.